Let's begin with the foundations. Welcome to another lecture. Today we consider the murder of Henry Nowak, a case that entwines criminal law, policing under pressure, religious symbolism, and the modern evidentiary orbit of social media. I am Professor Alexei. We will proceed carefully and, as always, with the record in view.
Hello everyone. I am Priyanka. I study how real human behavior shapes systems that are supposed to be neutral. I guess today we look at a very hard example of that and try to keep our thinking clear while we listen.
To frame our discussion, the case is straightforward in outline and complex in implication. In December 2025 in Southampton, 18-year-old student Henry Nowak encountered 23-year-old Vikram Digwa in the Portswood area. Minutes later, Nowak was fatally stabbed, 5 wounds including a lethal chest injury. There were no eyewitnesses to the stabbing itself. Subsequent proceedings addressed not only guilt, which a jury ultimately resolved, but also how police triaged the scene, how religiously associated items were understood, and how public debate escalated after body-worn camera footage was released. It's important to understand some terms. Kirpan, a Sikh ceremonial knife symbolizing duty. Sizes and practices vary. In this matter, evidence distinguished a small concealed kirpan from a separate larger ceremonial dagger worn externally. The larger blade, about 21 centimeters, was the murder weapon. The Nihang order, a Sikh warrior tradition with distinct symbols. Expert testimony here emphasized that wearing the larger external blade was not a strict religious requirement. The Independent Office for Police Conduct, or IOPC, the body that investigates serious incidents involving police in England and Wales. The police response in this case was referred to the IOPC. Unduly Lenient Sentence Scheme, or ULS, a mechanism by which the Attorney General may refer certain Crown Court sentences to the Court of Appeal if they appear too low. Multiple requests were made after sentencing in this case.
Maybe just to check. When we say kirpan here, we are not using it loosely. The court drew a line between the small, concealed article and the larger, outward dagger that caused the fatal injuries. And an expert clarified that the larger one is not a strict faith requirement. That feels important later when we talk about policy.
Indeed, the precision of language matters because imprecision sometimes migrates into policy debates. Moving forward, why should we care beyond this tragedy? First, modern policing under uncertainty. The footage shows how an initial suspect narrative can shape officer behavior before medical priorities assert themselves. Second, legal interpretation of religious freedom. Courts may recognize symbolism while rejecting any suggestion that faith compels unlawful use or risky carriage. Third, public policy in an age of instantaneous video. Body-worn cameras and social media can stabilize timelines, yet destabilize public trust if conduct appears misaligned with training or ethics.
And historically, people have misunderstood ceremonial knives in public spaces. So we see cycles of fear and sometimes backlash against Sikhs. Then, counter-cycles of education and clarification. I think this case triggered both patterns at once. Basic facts. In December 2025, Henry Nowak had been at the Hobbit pub. Toxicology later placed him under the drink-drive limit. He recorded a brief altercation on Snapchat. In it, he said, "You are a bad man. Say you are a bad man." And Vikram Digwa replied, "I am a bad man." Minutes later, Nowak was stabbed 5 times. The fatal wound was to the chest. There were also leg wounds, and a blood trail showed he tried to flee by climbing over a fence.
As we continue. Evidence showed that Digwa carried 2 ceremonial knives that night, a small kirpan under clothing and a separate 21-centimeter dagger worn externally. The latter was used in the killing. After the stabbing, he called his parents. His mother, Kiran Kaur, took the knife and hid it at their home. Police arrived. Body-worn camera captured officers speaking with Digwa, while Nowak, handcuffed, repeatedly said, "I have been stabbed and I cannot breathe." An officer replied, "Do not think you have, mate." Nowak became unresponsive before any medical call was made and was pronounced dead at 0037. The chronology continues. In May 2026 at Southampton Crown Court, Digwa pleaded not guilty to murder, manslaughter, and carrying a knife, and Kiran Kaur pleaded not guilty to assisting an offender. Later in May 2026, the jury convicted both. In June 2026, the judge imposed life with a 21-year minimum on Digwa and scheduled Kaur's sentencing for July 2026. The judge stated he was sure Nowak had not used racist language, that Digwa's account was wholly false, and that Digwa had no injuries. In June 2026, police released the body-worn camera footage, and public reaction intensified. The IOPC referral proceeded. As footage circulated, political figures weighed in. For example, Keir Starmer called it an awful, shocking case and welcomed independent scrutiny. Nigel Farage alleged two-tier policing in an online video. Elon Musk condemned the officers and offered to fund civil and private actions. It is crucial to understand that such political claims are commentary, not judicial findings. The oversight process was ongoing.
Also, Sikh community bodies responded. The Supreme Sikh Council announced a review of safeguards and educational responsibilities, and the UK Sikh Federation reported a large increase in anti-Sikh hate crimes, writing to Shabana Mahmood, so the societal echo was immediate, and not only about the police.
Before we get to the complexities, a brief personal note. As a mathematician turned legal evidence dilettante, I am fascinated by what we might call the mosaic problem. When there are no eyewitnesses, how small tiles of data, a Snapchat clip, a blood trail over a fence, a covertly recorded exchange between brothers, pathology of wound angles, tessellate into a persuasive whole. In chess, combinations emerge from quiet moves. In law, combinations emerge from quiet facts. This logically leads us to three big questions. Why did the self-defense claim fail? What if comprehensive street CCTV had captured the stabbing? And how should we approach ceremonial knife laws today? We will treat each in turn. Big question one. Why was self-defense rejected? The prosecution relied on a mosaic. First, the Snapchat video showed Digwa walking away while Nowak spoke to his camera. That undermined any claim of immediate peril at the point of filming. Second, the pattern of wounds. A fatal chest wound plus cuts to the legs, with a blood trail over a bin and fence, supported that Nowak was trying to escape after being stabbed, and that force continued or pursuit followed. Third, the absence of injuries on Digwa was a classic red flag for mutual combat narratives. Fourth, a covertly recorded Punjabi exchange with his brother at the scene. The brother advised him to claim self-defense, and Digwa replied the claim would fail if street cameras existed. That suggests consciousness of guilt rather than spontaneous fear. Fifth, post-offense conduct. His mother hid the weapon. Juries correctly view evidence concealment as tending against innocence. Finally, the body-worn camera was chaotic, but the victim said at least 9 times, "I have been stabbed and I cannot breathe." The suspect, by contrast, spun uncorroborated claims of racist abuse and turban pulling that the judge later said he was sure did not occur. Taken together, we observe an evidentiary gradient away from self-defense and toward deliberate lethal force.
I am curious about the expert testimony part. Specifically, did the expert on Sikh traditions influence the jury on intent, or only on whether carrying that larger external blade could be framed as religiously necessary?
To elaborate, expert Professor Gurnam Singh did not opine on intent in the psychological sense. Rather, he bounded the religious context by stating that the larger outward blade linked to Nihang symbolism was not a strict requirement, and that there was no good reason to wear it. He removed any implication that faith compelled carrying a 21-centimeter dagger in public. Legally, this matters because it precludes a juror from rationalizing the presence of the weapon as unavoidable. Intent to kill or cause serious harm was then inferred from forensic pathology, the wound pattern, the pursuit indicators, and the surrounding digital evidence. In simpler terms, the expert narrowed the stage. Forensics and conduct wrote the script.
Moving on to the counterfactual. What if there had been comprehensive street CCTV that captured the stabbing itself, not just the before and after? Does that compress the timeline of truth? Or does it mainly compress the time it takes the public to form judgments?
Big question 2. The CCTV counterfactual. High-resolution, continuous video of the fatal act would likely have truncated the narrative space. First, legally, the self-defense claim might have been either immediately corroborated or immediately falsified. Counsel would adjust strategy accordingly. Judicial directions would narrow, and deliberations could be shorter. Second, policing on scene. If officers knew unequivocally within minutes that the victim had been stabbed while retreating, triage might have been prioritized more aggressively. Suspect management might have been more circumscribed, and the ill-advised allowance for a brotherly conference might have been avoided. Third, public perception. When the ground truth is visibly fixed, political claims such as two-tier policing have less oxygen, even if not extinguished. The debate shifts from what happened to why responders behaved as they did in the first critical minutes.
Can we maybe now look at public trust? If perfect CCTV existed, would trust in policing necessarily rise? Or, if the video only confirmed poor triage, could trust actually fall faster because the evidence is so stark?
Speaking of trust, video accelerates alignment with reality, but it does not guarantee comfort. If comprehensive footage confirmed that the victim's pleas were discounted while medical aid was delayed, the trust curve might dip more steeply in the short term. Yet accountability mechanisms, IOPC findings, policy revisions, training updates, could then begin earlier, potentially hastening recovery of trust. Inversely, if footage corrected a misperception and validated training under chaotic conditions, trust could stabilize. Transparency is mathematically an information revelation. Its sign is determined by what is revealed and how promptly institutions respond. Big question 3. How should we handle ceremonial knife laws today? We start with legal baselines. Religious freedom protections acknowledge the kirpan as a symbol. Courts, however, draw a bright line at unlawful use. In this case, expert testimony distinguished small, customary carriage from a larger outward blade that is not a strict requirement. The latter introduces elevated public safety risk, and the court did not treat it as mitigating. Policymakers now face an optimization problem. Preserve legitimate observance, minimize weapon misuse, reduce communal backlash, and provide clarity to frontline officers who must make decisions in seconds.
I think the next thing we should talk about is the community responses. The Supreme Sikh Council said it will review safeguards in education. The UK Sikh Federation reported a big rise in anti-Sikh hate crimes and asked for stronger protections. So, how do we balance religious freedom and public safety without inviting a wave of suspicion towards Sikhs who observe in good faith?
To elaborate, A workable balance typically combines narrowly tailored exemptions that specify size, manner of carriage, and context, clear guidance to police on what constitutes lawful, culturally respectful engagement, community-led education on responsibilities, storage, and safeguards, and rapid, even-handed enforcement when unlawful use occurs. We also require data. Jurisdictions should track incidents involving ceremonial items separately from generic knife crime to avoid conflation. It is worth noting that proposals to prohibit ceremonial knives in public will surface after cases like this. Yet blanket prohibitions can overshoot, harming religious observance while failing to address criminal intent that ignores prohibitions anyway. In conclusion, precision beats generalization. Education plus enforceable boundaries outperform symbolism bans.
From a different angle, maybe we need research on first responder scripts. Default to medical stabilization when someone alleges stabbing, even if the suspect is speaking confidently. Also, scenario training on separating parties quickly to avoid coaching. Because here, allowing a conversation between brothers produced evidence, but it also signaled weak scene control.
Agreed. Additional research gaps include the effect of body-worn camera release timing on protest dynamics and officer safety, the comparative impact of social media clips versus official footage on juror expectations, and the calibration of sentencing remarks that explicitly decouple crimes from racial narratives, as the judge did here, to reduce communal tension while preserving accountability. These are not merely academic. They are levers that alter outcomes on the ground.
So, I guess that kind of sums it up. We examined the murder of Henry Nowak, the Snapchat video, the 2 knives, the pursuit evidence, and the body-worn camera context. We asked why self-defense failed, what comprehensive CCTV might have changed, and how to approach ceremonial knife laws without harming legitimate faith practice.
To summarize, this was a case about murder, not about racism as the judge emphasized. Yet it sparked debates about policing, policy, and communal safety. For further study, consider how social media evidence shapes both courtrooms and streets, chain of custody, juror cognition, and protest dynamics all intersect there. This then completes our present analysis. Thank you for listening.
Thank you, Professor. And thank you to everyone who joined us. Until next time.